Senator, thank you very much. I want to say three things. First and foremost, I want to thank both of the speakers this afternoon. I think you've done an excellent job helping us be informed about both sides of this perspective, and I certainly appreciate having both of you and have learned at least some facts from the both of you. So thank you so much for sharing your time and your expertise, and I look forward to continuing to work with you folks. Second, I think that I want to respond, generally speaking, to Mr. Kaluchi's presentation, and not to take away anything from what you're saying, because I completely understand, if the world or society is a pendulum, and we're trying to, it is possible to swing the pendulum too far in one way, and in no way, shape, or form should police officers be subject to any sort of harm or threat or violence or anything of that form. But as you were speaking and presenting your argument, I thought you did a really good job. And as you were making your argument, I'm imagining like the scale of justice in this case. Suppose this case is about whether or not we should change the LEOBoR, and for every point you make, you're placing something heavier and heavier on your side to win. I would just speak to what is on the other side of that argument, and that is the fact that on the other side of police misconduct is often, for example, my career as a public defender, I've represented thousands of people in criminal cases, mostly poor, mostly from low-income communities, mostly minority, often don't speak English. And the concern is that when you have a process like LEOBoR, it makes it harder for folks who are particularly from vulnerable communities to get justice. For example, we have our Supreme Court has interpreted the resisting arrest statute to say you have no right to resist arrest, whether it's a legal or illegal arrest. Think about what something like that does. So if I walk out of my house right now and somebody chooses to arrest me, if I resist that, whether it's their reason or not, that's illegal. And I've seen complaints, arrests, with one count illegal arrest, which begs the question, what's the arrest for? The broader point I'm making there is that as bad as some of these concerns are, folks losing their jobs and being subject, ultimately being a police officer is something that someone can make an informed choice whether to do or not to do. Whereas the harm that exists on the other side of the equation is to folks who are civilians, right, who are not doing anything other than existing. And some of the examples that Attorney Rogasta gave, a lot of these folks, they're not doing anything, right? They're not being punished for what their profession is or whatever. Sometimes it's for their skin color. And so I just want to make sure that this record of this panel shows that while we're mindful of the due process due to police officers and certainly don't want any harm or threat or anything unreasonable, there is another side to that equation. That is the civilian community, and folks who are walking down the street deserve to have their Bill of Rights, the original Bill of Rights, the constitutional Bill of Rights, be upheld. I do have a question, and that is that there seems to be two main kind of recommendations here that are ruling the day. One is the composition of the panel, and I've heard from both of you on that. The second, the length of the suspension, and I've heard from both of you on that. The third, at least in my opinion, is that there's a collection of parts of the LEOBoR, particularly in the subsections 3 and 5, that really, in my opinion, and I'm curious, just my question to both of you is whether you agree or disagree, that these collection of provisions serve as an obstacle to truth finding in terms of the investigation. What do I mean? For example, as far as the process or the interrogating process, the interview process is concerned, there's a bunch of provisions that are reasonable that should be subject to everybody, but there's also a lot of things that I think will get in the way of truth finding. For example, police officers under the LEOBoR may only be interviewed by one officer at a time. That officer must be a colleague of their department. The officer being questioned must be informed of who that officer is. They must be given a complaint, a draft of the complaint against them ahead of time. And those four things are mainly it. And so I wonder if you were to flip some of those things. For example, let's say instead of having an officer in your own department question you, maybe you have some sort of independent investigator come in. Instead of having the complaint ahead of time, maybe you don't have the complaint ahead of time. And so in terms of truth finding, I think those measures would go a long way. As far as I have seen, I don't think any of that is in the bill that Attorney Rogasta was speaking to. And so I'm wondering if either one of you have an opinion as to what might be that third big bucket of reform that we push or should be pushed if our goal is truth finding in the end.
Well, yeah, those are great questions. But I want to, this keeps bringing me back to why do we have such a high rate of resolutions, whether it be 94, 95, 96%? Because um, officers are compelled to give testimony. So, regardless of who's questioning, I don't think it really makes much of a difference. They know who's questioning them anyway. Um, but it's the fact that they are compelled to give testimony where a civilian does not have to. You know, if you're going to make an allegation against a civilian, you have to prove it against them. With a policeman, it's like, sit down, tell me what happened, and if you don't, you're going to be disciplined for not telling me what happened. So, again, we're not talking about the egregious cases. The egregious cases that involve criminality are going to go their own way. But the everyday disciplinary matter, they are resolved at a high level of resolution because, Mr. Bautista, exactly what you're saying. They are compelled to give testimony. It works. Otherwise, they could just keep quiet. Everyone has the right to keep quiet, but the policeman doesn't. So to balance that off with, hey, we're not going to surround you with 5 or 6 policemen, browbeating you into an answer. You're going to give us an answer. So you don't have to do the browbeating. You have to answer. So to balance that off, I think when the LEOBoR rules were made, hey, well, let's make it a reasonable place and time, an opportunity to consult with an attorney, know the nature of the charges, because don't forget, sometimes something may have been under investigation for weeks or months. You bring an officer in and say, I want to ask you about what happened 2 months ago. He says, what are you talking about? What happened 2 months ago? So to be informed of the nature of the charges, what it relates, that's a kind of a reasonable balance before you're going to bring someone in and force them to talk to you. So if that answers your question.
Can I say two things in response to that? Number one, in criminal cases, and really in all cases, there's something like a 99, 98% rate of either plea or dismissal, right? Only 1% of cases go to trial. I don't think that that's evidence that most cases are getting resolved. As we know in the criminal courts, a lot of folks are coerced into a plea deal. And so I think that your 94% statistic work both ways. I don't think it's necessarily an indication that it's efficient. It's that, right now, for example, the suspension is 2 days. Police chiefs and management are incentivized, therefore, to take the 2 days as opposed to going to trial. So I don't know that that's an indication of success. And two, the one example I've given in the past, I was a resident assistant in college, an RA. And I remember one time I was questioned in some sort of allegation of wrongdoing. Nothing that I did, but I was just questioned about it. And I'll always remember, and I will always use this example in these conversations. They sat me down at a table, and all they said was, "What happened?" And the fear of God came into me because I didn't do anything wrong. But just the fact that I didn't know what they knew means to me that I have less room to wiggle around. And so I don't object, to the totality of police officers knowing something about what they're accused of. But as I understand it, they have to be given pretty specific information. And I think common sense would lead us to think that gives them the opportunity at least to massage their testimony in a way that's more beneficial to them. Those are the little nitty-gritty details of this LEOBoR that I think really need to be spoken about as much as the composition of the panel and how many days they're suspended. It's a truth finding thing. I don't think police officers should go there in the dark and the blind, but I think, I'll always remember that example. So tell us about what happened. Now you don't know where you can wiggle and where you can, and I think that's a very powerful thing.
Well, I can answer your question about the conduct of the investigation section. I tend to agree with Mike, and I also agree with your observation, Mr. Batista. These rules are a bit constricting. I refer to them as the rules of engagement, and I spend a lot of time with internal affairs investigators advising them how to go about this. Some of the rules are a little bit, I don't want to say silly, but probably unnecessary, like the 1 interrogator at a time rule. Normally, you have 2, sometimes 3 investigators in the room, and someone may have a different viewpoint and may offer something. So I've actually told clients, hey, look, to avoid a fight over the violation of the 1 interrogator at a time rule, if there are 2 cops in the room interrogating another cop, and one is doing the questioning and one has another thoughtful question, write it down, hand it to the interrogator. That way we don't do it. I mean, it's a little bit silly, but I will say this. I agree with Mr. Kaluchi. I think that section of LEOBoR has actually worked fairly well. It provides a structure and everybody knows the rules of engagement. The summary punishment is probably the most serious issue because so many police chiefs that want to avoid the expense of LEOBoR try to figure out how they can take an offense that's worthy of far more than 2 days and somehow make it fit